Molo Sanbonani, hello, how's it? Good day, people. Shalom, welcome to it. It is vlog 132 here on the Big Daddy Liberty Show. It's going to be a relatively quick vlog, if anything, because there is a breaking news, effectively. The Constitutional Court, having passed a very important judgment today, handed down a court finding basically declaring invalid the preferential procurement regulations of 2017. These are the regulations, of course, that the Minister of Finance had tried to shove through under the Preferential Procurement Policy Framework Act number 5 of 2000. Lots of legalese in that introduction, so let's not rely on me to explain what this all means, but it has massive implications, of course, for the BEE policy, that is race-based legislation in this country, where the government gives itself the power to pick winners and losers based on race. Effectively, in my opinion, a racist policy. But don't take it from me once again. As I said, I have the attorney, or rather the lawyer, who fought this particular case and won it in the court. I'm talking, of course, about Willie Spies. There he is on screen. First time on the show. I'm very, very, very excited to have you on, Willie. Good afternoon.
Good afternoon, Cecily, and thank you for the opportunity.
Awesome. Willie, I really wanted to chat to you because, you know, you put up that wonderful banner of victory, I'll call it that, in your tweet today, basically showing that court order from the Constitutional Court. I'm going to put an excerpt of it on the screen. Just give me a moment, just so that the viewers can understand exactly what we're talking about. And there it is on screen as Willie is dealing with a quick message, which is totally fine. I'll put this on the screen so that people can see what exactly we're finding here. The Constitutional Court, of course, making an order on appeal from the Supreme Court of Appeal. That's a hearing from stemming from a hearing, pardon me, from the High Court of South Africa in the Gauteng division. Those four orders made by the Constitutional Court there. Willie, can you quickly talk us through this court order? What does it mean, and exactly who are the parties involved in this court case?
Yes, Cecily, firstly, the applicant, the primary party in the application was described as Afri-Business. Mm-hmm. It has since then changed its name to Sake Liga, or I'm not sure whether you use the English translation, business.
Nee, ons sê Sake Liga op die program.
Okay. So Sake Liga was the main applicant in the application. They brought the application, as you correctly stated, back in 2017. Unfortunately, unsuccessful. The matter was then appealed to the Supreme Court of Appeal, successfully so. Mm-hmm. And then the minister and the state attorney obviously filed an appeal to the Constitutional Court. Mm. And what the Constitutional Court actually did here was to dismiss the appeal of the state attorney, which means that the ruling of the Supreme Court of Appeal is upheld, and the ruling by the Supreme Court of Appeal is the one that will be standing, which means that, as you correctly said in your introduction, that those regulations published by the Minister of Finance, which aim to impose a preferential procurement, is not a strange thing. It has been, I think, every single government in the world make use of it. Mm-hmm. The purpose of it normally is to help small business, to enhance newcomers into the market, etc. But what usually happens is preferential procurement gives the smaller guy a 10% advantage. They can quote a 10% higher price, but they will still be competitive. And that's understandable. It's a way to develop the economy. It's the way the state makes a contribution to the development of the economy. But what the minister did with these regulations was to go haywire, mm-hmm. and in fact create a preferential policy framework that enabled or disabled companies, and I'm not talking about pure white companies, even a company which is black empowerment but not majority black owned. Those companies are also disqualified. They're totally disqualified from entering appearance. You will see that one of the companies who tried to get on board in the litigation was the Fidelity Group, which is a security company.
That's right.
Their application to intervene was dismissed, but I think they're not too sad about the dismissal of their application, because the main application still succeeded. And the important thing is that a company like that, which is a company with black shareholders, it's a company that employs many, many people in the security industry, they stood to lose all their government contracts as a result of these policy frameworks. And that created an unbearable situation. That's why it was important for Sakeliga to intervene. And that's why it's also an important thing for the business community as a whole, that although by a very small margin, and we could talk perhaps about the interesting division within the Constitutional Court, but with a very small margin, the majority of judges ruled that these regulations actually went too far, and that the minister actually went beyond his powers, and that as a result, the regulations has been set aside.
Absolutely. And, even as you say this, Willie, and as we wrap up the conversation, because, these vlogs are always meant to be a short, quick, punchy feedback for people. No. You're actually perfect insofar as you answered all of the questions I was going to ask anyway. But I suppose that final question therefore becomes, what does this then mean? Because from my perspective, just to give my quick view on this, I'm not in favor of any legislation that sees government give itself the power to pick winners and losers in society based on race. I believe it's just purely racist. Even if the intention's always very good, to say, look, because of our past and we need to rectify it. I understand the intentions, but I'm always of the view that you can achieve the very same intentions of uplifting those who are disadvantaged in the past in a non-racial way. But that's not the issue here. The issue here is this judgment obviously now has great implications for maybe making that argument a bit better, for a non-racial approach. Obviously it's very early and it's not necessarily sorry, I'm being trapped by my own sentence construction here. Let me take 2 steps back. This judgment obviously isn't an attack necessarily on the status quo of the government using race to decide winners and losers. That still stays in place. Insofar as the law itself, the act, is still in place, right? The preferential. But the regulations were literally deemed invalid because the court maybe appreciates that there is a limit, isn't there?
Yes. I think that's the important thing. And we should remember that the minority judgment was still given by 4 judges.
Yeah.
So there are still 4 Constitutional Court judges who believed that this was fair, that was okay. And unfortunately, that to a very large extent, I think the perception has started to develop that the Constitutional Court leans heavily towards the transformation ideology as exercised by the ANC government. Obviously, transformation in itself is not wrong, but the ANC has put a particular spin to it, which makes it draconic in certain instances, and as you correctly stated, even racist in certain instances.
That's right.
Unfortunately, the history of the Constitutional Court for the past 20 years was that the court would be very, very slow to go against the state with regards to transformational issues. So I think in that regard, this judgment is a landmark decision. I think this could be the very first of hopefully a series of judgments which could bring back the balance towards the middle. I think we've been on the radical side so far. And with regards to transformation, with regards to issues like the creation of an equal society, the eradication of past inequalities and so on, I think there was a bit of an imbalance that needs to be brought back to the middle again. Hopefully this judgment is the very first step in that direction.
Absolutely. You and I hope in that regard. I am talking of course, to Willie Spies, who is one of the head honchos at Herta Spies Incorporated. Willie, as we wrap up, how do the folks get in touch with you, if they want to enlist your services?
Well, they can give us a call. They can send us an email. The name of our firm is there. And our email address is admin@hurterspies.co.za, or you could even email me personally at spies@hurterspies.co.za. I'm happy to chat to anyone.
Excellento. That is, of course, Willie Spies from Herter Spies Incorporated. Major thanks for him and his time on the show. What do you think about this judgment? Maybe you're going to take a moment a bit later this afternoon and read it. And maybe see from your perspective, what its implications are for you. Maybe you're one of those businesses who is also very worried that you'd be locked out of economic opportunity because of those regulations which were deemed invalid by the Constitutional Court. Major victory by this law firm and the organizations that took it to court. Kudos to them for that. With that being said, thank you very much for watching this another vlog on the BDL show. If you want to support the work that I do, check out that info in the descriptor for how you can make a contribution to the show. Look out for the Big Daddy Liberty show tonight. I'll bring you my speech at the Free Market Foundation, where I'm very glad to be giving a Freedom Award from them tonight. So look out for that tonight at 8 p.m. With that being said, thank you for watching. And remember, as I always say at the end of every show, never trust a commie.